Yes.
Madam, I'll just refer to the principal point which the honourable member has made with his very wide experience as far as law is concerned. I've also had the opportunity of discussing with the honourable minister this subject. The point which has been made is that we have provided for adoption under Section 41 of this Act. This adoption which has been provided for and the scheme of adoption which has been provided for may run contrary to the Hindu Adoption and Maintenance Act, particularly the provisions of Section 11(6), subsection 6 of that Act. Under the Hindu Adoption and Maintenance Act, the restriction is, and this was a restriction considered appropriate in 1956, the restriction was that if you had a son of your own or a grandson of your own, you could not adopt another son, because they probably felt at the time when the bill was drafted that the new son which is adopted, even after adoption, may remain a neglected child in the family and may not get fair justice. That's probably the reason. Similarly, a provision was there that if you already have a daughter or a granddaughter, then you are barred from adopting daughters. Now, that's as far as the law of adoption is concerned. That law is applicable only to those who are Hindus, Jains, Buddhists, on whom that law is, Sikhs, whom that law is applicable. Now, this legislation which has been brought is a social legislation with a social purpose and does not deal with a primary emphasis on adoption. The primary emphasis of this is that we have lakhs and lakhs of abandoned, neglected and orphaned children in this country. In every city, you have street children, you have children in orphanages. Therefore, there has to be some scheme under which rehabilitation of those children can take place. Section 40 of this Act mentions that the rehabilitation and social reintegration of a child shall begin during the stay of a child in a children's home or a special home. So you create these institutions. And the rehabilitation and social reintegration of the child shall be carried out alternatively by 1, adoption, 2, foster care, 3, sponsorship, 4, sending the child on an aftercare organization. Therefore, you work for an integration of the child with the society by these 4 methods, that is adoption, foster care, sponsorship, sending him to aftercare organizations. Now, as far as adoption is concerned, they say in the case of adoption where a child lives with the family itself, becomes a member of the family, the primary responsibility for providing care and protection to children shall be that of the family. Then the method of adoption is mentioned, and then the restrictions are mentioned. How do you adopt? No child shall be offered for adoption unless 2 members of the committee declare him the child legally free for placement as an abandoned child. And then it says, the board may allow children to be given in adoption to a single parent, which is contrary to the scheme of the 1956 Act, and to parents to adopt a child of the same sex, irrespective of the number of living biological sons and daughters. So we are now trying to consciously make a departure from the 1956 law. And the reason being that this law has nothing to do with the religion either of the child or the parent. This law is not a personal law. This law has nothing to do with religion. This law has to do something to do with a social purpose. The social purpose being that millions of abandoned children or neglected children or orphaned children must be picked up, either sent to the homes or be sponsored by well-to-do people, or even be adopted into the families of those affluent people. Now, this law is intended to encourage people who may be well off, commercially, economically, socially well off, who have the resources, they may have a house, they may have children, and they yet agree that to pursue a social purpose, we must either sponsor one child or take one child into adoption and develop that child, grow up that child as a member of our own family. Therefore, this is a special legislation for rehabilitation of these neglected children. Now, Chief Justice Mishra would bear out that the law has been always well laid out, that whenever for a special category, a special law is created, then it is that special law which will apply. Now, most of these children would be those we are not even aware of what the religion of these children would be. Because these children are orphaned. These children may immediately after birth have been left on the roads or in some place where the religion is not known. So their religion will not act as a bar because it may not even be known. The parents' religion will not act as a bar. What is being suggested is that to pursue that social purpose, to encourage well-to-do people to adopt these children or sponsor these children, you must either sponsor them or you can even adopt them into your own families. So this special law will have the effect in the case of these category of children, that is orphaned, neglected, abused children, of overriding the general law, which is 1956. So if there is any person who has to be adopted, who is not in the category of orphaned, abandoned, neglected or abused, that law will apply. But for this category, if through these institutions somebody is to be sponsored or adopted, this special law will apply. And this special law will defy the religion of the child, it will defy the religion of the parents, and therefore this law itself will apply. So I would request Justice Mishra to consider this point, that in view of this special legislation and the social purpose of this legislation, this amendment really, or this suggestion may really not be pursued, and it is not even necessary to pursue the suggestion to say that in whichever family you are adopted, you will follow the religion of the parents, because this law has nothing to do really even with adoption. Traditional customary adoption law, it has nothing to do with religion. It has something to do with rehabilitation of orphaned and neglected children, and therefore for those category of children, the 1956 law itself will not apply.
As a social obligation.
It's a social obligation.
Then let him finish. Let him finish, please. Let him finish. There are a lot of opinions, I know, but let him complete what he wants to say.
Now, the effect of this, the second point which has been raised is, it's a general point that there are certain drafting words, etc. Though the specific details have been given, I've been trying to compare a list which was given in the other house. The Honourable Minister also went through that entire list with the members. If there is anything specific, I'm certain the Honourable Minister could go into those questions, but from what was given to us in the other house, it was discussed at length and it was found that really there is no inconsistency, because a large number of the amendments really related to use of word the, some related to replacing it with a more suitable phrase. But the tenor of each of those clauses where those words have been used substantially is not any different whether those words are there or are not there. So I would request the Honourable Member to consider if any such area where the use of a particular phrase is creating a different emphasis as such.
Now I have before me, just a minute.